ability of the mental health testimony or the reports that they've written. I'm not an attorney. I'm not giving you legal advice how to cross-examine. I'm talking from a psychologist perspective as to where they are vulnerable. The other audience is family law attorneys who are representing your clients, and how do you go about um, undermining or impeaching the mental health testimony that's problematic um, because of professional practices there. So last time I spoke sort of generally about the incompetence issues and the ethical violations involved, and sort of set the stage for uh, where the cross examination is going. And you can't do cross examination if you're a parent or an attorney. You can't do it sort of by rote based on what I'm saying. You have to sort of understand the concepts, because that mental health person is going to try to avoid a lot of the um, situations, the double binds in the questioning that you're moving down. So, understanding the concept will then allow you to adapt the questioning to what's actually happening in the courtroom. So, let's start by looking at cross examination. And today I want to talk about the cross examining mental health testimony when there's no diagnosis in the custody report. And that's pretty much all the time. They never diagnose the pathology. And that's a serious problem for them, because the diagnosis means the same thing as identify, and they're not identifying what the problem is. And um, that's where the thought disorder kinds of came in. And as I discussed last time, they've left the field of clinical psychology. I have other seminars about that, where they're doing something different. This forensic custody evaluation approach, where they don't diagnose the pathology. They not clinical. They don't agree with the clinical psychology approach, but that's going to be extraordinarily problematic for them in the cross examination. So I want to talk about that today. So the first, I'm going to start at the end. This is where we're going to wind up, is on ethics code violation to 9.01 bases for assessment. And this says a psychologist base their opinions contained in their recommendations, reports, and diagnostic or evaluative statements, including forensic testimony. So they're making sure that they include the forensic psychologists in this, that we base our opinions on information and techniques sufficient to substantiate their findings. And that's where the vulnerability is going to be. They did not base their opinions on information sufficient to substantiate their findings, and they did not base it on techniques sufficient to substantiate their findings. So both of those are going to be problematic for them. And then you see it as see also standard 2.04 bases for scientific and professional judgments. We'll cover that one in a second, or an additional seminar. 2.04, that's based on their report, and you can extract that they didn't apply delusional thought disorders, family systems, attachment. They applied none of the established scientific and professional knowledge of the discipline as the basis for their professional judgments. But that's a violation of 2.04, and I'll discuss the ethical standard violations separately. In this seminar, or in this talk, I just want to focus on their failure to provide a diagnosis in their report. So the information that we're going to look at is the delusional thought disorders. You can also look at family systems, and I'll do that in a separate discussion of how they're vulnerable in that domain. There's a whole line of questions you can use on that. And then you can bring the two of them together, what we'll be talking about today regarding delusional thought disorders and the family systems, and you bring them both together to say they're not, their opinions are not based on information sufficient to substantiate their findings. The techniques is going to be the mental status exam of thought and perception. That's the assessment for a delusional thought disorder. So if they didn't do that, then they didn't assess for a delusional thought disorder. So they're kind of in trouble on that, because that's what the pathology potentially is in the family. So, to begin with, just some um, uh, terminology kinds of things. So, the term diagnosis means exactly the same thing as identify. The term pathology means the same thing as problem, and the term treatment means the same thing as fix it. So, we must first diagnose what the pathology is before we know how to treat it. We must first identify what the problem is before we know how to fix it. So you can use those words interchangeably, and that's where these forensic psychologists are a little thought disordered on things because they'll say when you ask them about diagnosis, they say, "Oh, I don't like to diagnose pathology. I don't like to pathologize the people." But that they're saying, I don't like to identify what the problem is because I don't think identifying the problem is useful. Uh, that's thought disordered. How do you know what to do about a problem if you haven't first identified what the problem is? But they just go, and the reunification therapists, there's no such thing, but they do the same thing. They start treatment with, but treatment of what? Are you treating cancer or diabetes? You haven't identified what the problem is. You haven't diagnosed what the pathology is. And it's just for professionals, we're not your local, car mechanic or plumber or something. We're a doctor. And so we need to identify the problem. We need to diagnose the pathology at a professional level. And so their reports, when I do my second opinion reviews of their, I'm the meaningful scrutiny of their defective reports. When I read their reports, I shouldn't have to guess at what the diagnosis is. That between doctors, that's why you read medical reports. A doctor puts a diagnosis down because other doctors then can rely on that diagnosis or challenge it as a misdiagnosis. And that's what I will do in a lot of these cases because they're practicing beyond the boundaries of their competence. And so they've misdiagnosed the pathology. But how do we know if they've misdiagnosed it if they haven't even given a diagnosis? If they haven't given a diagnosis, they have misdiagnosed it by definition because whatever it is, they've missed it because there's no diagnosis. So it's a misdiagnosis by definition. So that's why, as a clinical psychologist, I was taught, always taught, to put your diagnosis on all formal paperwork because otherwise you're going to misdiagnose the pathology by definition. You missed it no matter what it is. So put your diagnosis down. If it's a possibility, put rule out. That's what that means. You rule it in or you rule it out. A rule out diagnosis means a possibility because otherwise you open yourself up to this type of questioning that we'll be going through here. So, what we're gonna, the issue is, or returning to terminology for a second, a persecutory delusion is a thought disorder. And so that's where the linkage that we're going to make for them. And where the focus is, we have a persecutory delusion, a thought disorder, and then we link that to child psychological abuse. Would creating a shared persecutory delusion in the child that destroys the child's attachment bond to the other parent be a DSM-5 diagnosis of child psychological abuse? Yes, it is. And so we're linking the delusional thought disorder to a DSM-5 diagnosis. Now they say, I don't like to diagnose pathology. Well, that's very interesting, but if it's child abuse, you're not going to identify that there's child abuse in the family. You're not going to tell the court there's child abuse in the family. And so they can get themselves all wrapped up in that. And especially if you move over and start using the term identify, you don't identify when there's a delusional thought disorder. Is that correct? You don't tell the court when there's well, I would if there's child psychological abuse. And the first question that's going to start to get them into trouble, and you can apply these questions as appropriate to the situation as you're doing your cross examination. But this is, the possible question. And mental health people, my psychology people, we're scared little bunnies. And so we don't like uh, you know extreme answers. We don't like things that are always or never. We like to stay in the safe zone, and we believe that the safe zone is possible. The problem in this case is that's not the safe zone when it comes to diagnosis, because as doctors, we have to identify what the problem is. We have to diagnose it, yes or no. Is child abuse present? Yes or no. And if we haven't done that, we have to get the information necessary to do that. That's our job. If you don't want to diagnose pathology, don't be a doctor. Go do something else. Be, a stockbroker or something. But if you're going to be a doctor, the responsibility is to identify what the problem is with clarity. And so the question is it possible there's a persecutory delusion in the parent shared by the child? Is that possible? And they're going to answer yes. If they say it's not even possible, they're taking an extreme position, and then they're going to have to support that. Did they do a proper assessment? What is the proper assessment? And they didn't, and they don't know what delusional thought disorders are or how to assess for them. And so if they're offered that question, is it possible it's a persecutory delusion in the parent shared by the child? They'll say, well, that's a possibility, and that's where we're going. Where we're headed on these questions. But there's potentially some questions you can set them up with ahead of time on this. And so the assessment question after is it possible? Did you conduct an assessment for a possible delusional thought disorder, a possible persecutory delusion? Well, that's a problem for them because no, they didn't. And they don't know how to assess for it. So, what we'll be doing on these questions is exposing their practice beyond the boundaries of their competence. And that's, returning sort of back to the initial talk last week, is they are practicing beyond the boundaries of their competence and they don't know the necessary knowledge, so they don't apply the necessary knowledge. But these questions are going to be looking at that and exposing the fact that they neither know or apply the relevant established knowledge of professional psychology to their assessment. So, did you conduct an assessment for a possible delusional thought disorder, possible persecutory delusion? If they answer yes, they're in trouble because it's a mental status exam of thought and perception. You ask them, okay, so how did you assess for that? Where in your report does it discuss your assessment for possible persecutory delusion? Why did you rule out? Why did you say that's not present? There's no persecutory delusion. And they don't even know what it is. That's not their domain. They're getting blindsided by these questions. They just came over to the family courts, and you're allowed to just make up opinions. So that's what they're just doing, and they haven't done the necessary background work to become competent. So if they say yes, that's going to be put them in that danger position of then having to, point out where in the report they did it. If they say no, they didn't conduct an assessment for possible persecutory delusion, they're in equal trouble. Ask them why not. Well, I didn't think it was necessary, or and they'll start to fumble. And as they do that, their stress level is going to get really high. And that's what you want. You want them doing a risk assessment with each question as to what's the most dangerous or what's the least dangerous answer to this question. So why not? Why didn't you assess for that? And you don't have to pin them down on any single question. You're establishing a cloud of incompetence around them. And so whatever they just say. And also, for the most part, you want to hold them down to yes or no questions. Don't let them go too far afield on things. So, what is the assessment for a possible thought disorder? So, that's going to expose them even more on this. So, why didn't you assess for a possible delusional thought disorder? And uh, what is that a proper assessment for that? And they don't know what that is. And you can follow that up then with, what that is. That's a mental status exam of thought and perception. But for the delusional thought disorders, the relevance of that is, I would use the quote by Walters and Friedlander. It's in the journal Family Court Review, and in these two quotes from Walters and Friedlander, they indicate on four separate occasions that it could be a possible delusional thought disorder. So, some resist refuse dynamic, that's the forensic term for the pathology. There's no such thing. But if they put that in the report, they linking it to it. The parent's underlying encapsulated delusion about the other parent is at the root of the intractability. Notice they cite me in that, so I know what I'm talking about here. An encapsulated delusion is a fixed, circumscribed belief that persists over time and is not altered by evidence of the inaccuracy of the belief. It's a fixed and false belief that's maintained despite contrary evidence. That's how it's stated in the professional, if you work with them. That's not Dr. Childress saying that. But notice it's in the journal Family Court Review, their own forensic journal. So they should know this, and they should know it's a possible delusional thought disorder. When alienation, that's also doesn't exist, but so if they've used resist, refuse, or alienation, they've connected themselves to these quotes. So when alienation is a predominant factor in the resist, refuse dynamic, the theme of the favored parent's fixed delusion often is that the rejected parent is sexually, physically, and or emotionally abusing the child, and the child may come to share the parent's encapsulated delusion and regard the beliefs as his or her own. So there we have a clear indication that they should have considered a possible persecutory delusion. Going back to that other possible question, is it, you have them read this quote and say, is it possible there's a shared persecutory delusion in this family? Why not? Did you rule it out? Did you assess for it? What is the assessment for a persecutory delusion? And the assessment for a delusional thought disorder is a mental status exam of thought and perception. And so you ask them about it. What is the assessment for that, for a delusional thought disorder, doctor? And they go on and they pontificate for a few seconds. And you say, what's a mental status exam of thought and perception? Because you know more than they do. And you become dangerous to ignorance when you know more than ignorance does. So what is a mental status exam of thought and perception? Good luck, and let them explain whatever they think it might be. And then you say, are you trained in conducting a mental status exam of thought and perception? That's going to be interesting, because no, they're not. And they may answer that. If they do, then they're practicing beyond the boundaries of their competence, because this is a possible delusional thought disorder. The assessment for that is a mental status, but they don't even know how to do that. So you get them admitting on the stand that they're not competent in assessing the very pathology that they are tasked with assessing. And if they say yes, well, where did they get their training in the assessment of delusional thought disorders? And we'll take a look at Martin, and that's where, if you Google Martin down at the bottom, if you just Google mental status exam, it's the NCBI, National Institute of Health website there, and they list this article by Martin talking about all the different mental status exams. There's one for language and attention and memory and all these different mental status exams. The one for delusion is a mental status exam of thought and perception. It's a very linear approach to conducting your assessment that will pop out the delusion right in the session, and you can take a look at it. So thought and perception, the inability to process information correctly is part of the definition of psychotic thinking. How a patient perceives and responds to stimuli is therefore critical psychiatric assessment. Does the patient harbor realistic concerns, or are these concerns elevated to the level of irrational fear? That's directly relevant to what we have. Is the child's fear of the targeted parent, is that a realistic concern, or is that elevated to a level of irrational fear? Is the patient responding in an exaggerated fashion to actual events? There's a child and the other parent, or is there no discernible basis in reality for the patient's beliefs and behaviors? So that is exactly what the differential diagnosis is that we're looking at. Is the targeted parent abusive of the child in some way? Is the child's fear realistic? Is the child's concerns about that parent realistic? Or are um, the child's fears and concerns elevated to the level of an irrational fear, or are they responding in an exaggerated fashion, no discernible basis in reality? Okay, so we got a persecutory delusion on one side, or we have actual child abuse on the other. That's what all mental health professionals should be assessing for, but they didn't in your reports and in these custody evaluations. They're coming in doing something different. They're not doing clinical. They're not thinking in terms of identifying the problem, diagnosing the pathology. They just think they can come in and offer an opinion based on absolutely nothing. So, the ultimately interesting question that you will land on is, should this family get another assessment for a possible persecutory thought disorder in the parent that's being shared by the child? The Another assessment. So in the initial questions around this and around family systems, so I would move family systems as well and do that in another line of questions and get them going. "Huh, I didn't really apply the knowledge of family systems." Then you switch over to delusional thought disorders and get them to acknowledge that they didn't really conduct a proper assessment for a possible delusional thought disorder. They don't even know what that is, and it's relevant to the situation. So then you ask them as they begin to become stressed about these things, and remember, they're doing a risk assessment with each answer. What's the least dangerous response for me in this situation when I don't know the pathology? And they're clearly going after my competence in delusional thought disorders, and I don't, that's not my domain. I'm in family courts. I'm not thinking psychotic disorders. So the question becomes, should this family get another assessment for a possible persecutory thought disorder in a parent shared by the child? So should we be getting it? And if you're able to expose enough of their ignorance and get them stressed enough to where they're going, "Ooh, is it possible?" Yes, it's possible, but you never identified that, and they're getting very stressed. They're likely to jump at this question as seeming to be a safe question. Should we get another assessment for Yes, we should. Yes, that needs to happen because I didn't assess for that, and I'm focused on custody, and that's a psychiatric pathology. So if you have concerns about that, that would be another possibility. But we should have concerns of Walters and Friedlander, and so they'll potentially jump at this question as it's seeming safe, and they'll say yes, but that's not the safe answer. If they say no, they're going to have to support that there shouldn't be, that you have ruled out, the doctor has ruled out a persecutory thought disorder for absolutely, and there's no need to get a second opinion on that if they answer no to this question. And they're going to be vulnerable on that. Where in your report did you discuss your assessment for the delusional thought disorder? Where did you learn how to do a mental status exam? So if they assert that they did the assessment, they're going to be in trouble. So they're likely to say, yes, we should get another assessment. However, if they do that, it opens them up to this 9.01 question, which is, if you did not assess for a possible persecutory delusion in the family, then are your opinions as contained in your recommendations, your report, your diagnostic and evaluative statements, including your forensic testimony here today, are your opinions based on information and techniques sufficient to substantiate your findings if you didn't even assess for a possible delusional disorder? And we know from Walters and Friedlander that's a possibility. And you're saying yourself, we need to get, another assessment for that. So no, your opinions that are being offered are not based on information and techniques sufficient to substantiate your findings if we still need another assessment to answer key questions in the situation. So that's going to be the final kind of point to this line of questions. Is it going to land up on 9.01? And I'll discuss the ethical standards in a separate talks individually. So there's three of them that kind of line up. The report is going to be absent the application of any established knowledge. They're not going to have applied family systems or delusional thought disorders or anything on attachment or anything really. If they apply parental alienation, there's no such thing. Resist refuse dynamic, no such thing. And so they didn't apply any knowledge. So they're vulnerable in their report on standard 2.04. And so when I do my second opinion reviews, that's what I'm looking for primarily in their report is did they meet the standard 2.04 and apply the established scientific knowledge? Then when they didn't, I will then look at their vita, and their vita will expose standard violation to standard 2.01 boundaries of competence. They don't even know the necessary knowledge. The reason they didn't apply it, 2.04, is because they didn't know it, 2.01. All the two standards on the APA Ethics Code are competence standards. So 2.01, boundaries of competence, 2.03, maintaining competence, and 2.04, bases for scientific and professional judgments, are all competence standards. And so they don't know the knowledge. They didn't apply the knowledge because they don't know it. And as a result, their opinions, as contained in their recommendations, reports, and diagnostic and evaluative statements, are not based on information, 2.04, and techniques, mental status exam, sufficient to substantiate their findings. So we got three ethical violations going forward. And then if they say, yes, we should get another assessment for this, or if they just acknowledge that they didn't conduct an assessment or don't know how to conduct an assessment for delusional thought disorder, the follow-up question, second question to the 9.01 bases for assessment is 2.01 boundaries of competence. If you are not competent in the diagnostic assessment of delusional thought disorders, and the pathology in the family may be a delusional thought disorder, are you practicing beyond the boundaries of your competence in assessing this family conflict? Now, notice that's a yes or no question. Okay, are you practicing? So, kind of hold them into that. Are you practicing beyond the boundaries of your competence? If it's a possible persecutory delusion, Walters and Friedlander, and you didn't conduct or don't know how to conduct an assessment for a persecutory delusion, are you practicing beyond the boundaries of your competence? Yes, they are. But that's the thought disorder, is that they'll go sideways on that. They don't make that link of you have to be competent in the pathology. If you're assessing autism, you have to know how to assess autism. If you're assessing, ADHD or an eating disorder or substance, you have to know how to assess for that particular pathology. In this case, Walters and Friedlander, a possible persecutory delusion, you have to be able to assess for it. If they don't, they're practicing beyond the boundaries of their competence. And so that's their thought disorder process. And if you stay linear and logical with them, you will be able to expose that. Now, for the parents, when you get kind of caught up in your motivational set where you want to prove the pathology to the judge, and so you're trying to get case specific with these mental health people, and get them around to admitting that the other parent was, lied about these emails and everything. And so you get lost in the woods, and you got to step back and see the larger forest that you're involved in. And what you want to do, what I would recommend you do as a clinical psychologist, and in matters of pathology, listen to your doctors. In matters of the court, listen to your attorney. But as a psychologist, what I would focus on is impeaching their testimony that they were on ethical violations and on boundaries of competence, and that they don't know what they're doing. And violation of 9.01, their opinions are not based on information and techniques sufficient to substantiate their findings. Once you impeach their testimony, then you can move to the more case specific stuff. And if you start asking, could this be a symptom of a delusional? Could this be a symptom of the delusion? Could this be a symptom of a delusion? And yes, it is. It could be. 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 It could also be you're abusing the child, but then we need a diagnosis of that, and that wasn't put in there either. Um, so, what's going to happen with them as you begin to go down the ethics lines with them and start to expose their ignorance on the stand is their stress level is going to go up considerably. And they're going to be doing these risk management assessments with each of their answers, which is exactly what you want. And so you probably when they first get up there on testimony, they're going to be all kind of pompous and arrogant because they think they've done this before and they think it's just their opinion. And as you, though, begin to hit on the ethical standards, the moment you hit on any ethical standards, their stress level is going to go up. The moment you hit on a persecutory delusion, when they don't know what that is, that's going to go up and they're going to start thinking, oh, wait, what did I assess for that? What's happening? And oh, my goodness, where are we going with this? Boundaries, competence, and all these sorts of things, their stress level. That's going to put stress chemicals in their brain and this risk assessment each time. Then, if you switch categories, so you start with family systems, you start with some easy questions that get, as they're pontificating, you set them up with some of your double bind questions. But then, as soon as you move into the ethical kinds of issues or expose that you're going to impeach their testimony and expose their ignorance, their stress level is going to go up. Brain chemicals for stress are going to go up. And over the course of the testimony, they're going to wear down in their ability to do these risk managements. And if you switch categories from family systems and you're talking about, Minuchin and the Minuchin diagram, then it's suddenly you switch over to delusional thought disorders. And then you move maybe over to attachment pathology. And then you come down to the ethics code. You're forcing them to change their context for evaluating risk management, family systems, then you have delusional thought disorders, and the APA ethics code, and each question they have to do. And so by the end of the questioning, they're going to be pretty exhausted on doing that, and they're going to lose track of what's the dangerous answer and what's the not dangerous answer. And actually, there is no not dangerous answer because they're thought disordered. So either direction they go, it's going to be bad for them. And it's called a double bind, and that's associated with trauma pathology. Um, so, what happens when they give no diagnosis in their report? And they do that consistently. No diagnosis in the child custody report. This is particularly thought disordered because they haven't identified what the pathology is in this, and that going to get them into a lot of trouble. So, no diagnosis indicates that there is no diagnosable pathology present. That's all of psychology, all of healthcare. If there's no diagnosis, that means there's no diagnosable pathology present because If there was a diagnosable pathology present, such as schizophrenia or child abuse, the mental health professional would have diagnosed it and told the court, right? Okay. So that's the domain that they're vulnerable in. When they didn't put a diagnosis, they are asserting for a fact that they have verified that there is no diagnosable pathology. Because if there was, they would have diagnosed it and told the court. And where this is going to land is on child psychological abuse and delusional thought disorders. They are asserting by no diagnosis that neither of those are present, because if they were, they would have identified those and discussed it and told the court, but they didn't. And because there was, uh, because if there's a diagnosable pathology such as schizophrenia or child abuse, the mental health professional would have told the court. Now, the mental health professional has an obligation and to discuss what it's possible as well. And that's called a rule out diagnosis. So you can rule something in or rule out. And so it's a possibility. So if I say there's ADHD, that's my diagnosis, but rule out autism. I'm saying autism might still be a possible diagnosis for these symptoms. So, because there is no diagnosis of child psychological abuse, a DSM-5 diagnosis, not even by a rule out, they didn't even put rule out child psychological abuse or rule out persecutory delusion. That means that there is no psychological child abuse in the family for a fact that they have verified, or else they would have put that diagnosis and told the court. And if it was a possibility, they would have put it by a rule out. So the fact that they didn't put it and they didn't discuss it with the court and they didn't indicate to the court that that's a possibility, then they are indicating by no diagnosis that it's not even a possibility. So now going back to them being scared little puppies, if you bring that up, that it could be a possible persecutory. Yes, it's possible. Well, then that would be possible child psychological, but you didn't even put it by a rule out. Now they're starting to go really stressed. And that's their problem because they didn't consider that diagnosis. They didn't conduct a proper assessment and they didn't discuss that issue with the court. And so they didn't raise that issue and um, um, discuss it. Either rule it in or rule it out. They just said it's not even present because they don't diagnose pathology and they left clinical psychology and started to do their own thing. Um, so pull this up. So to set up the double bind on this, the question to do that is, I notice you didn't put a diagnosis in your report here. Does that mean there's no diagnosable pathology present in the family? Now that's kind of a reverse way to answer this. So they'll say yes. When what is there a diagnosable pathology in the family? Well, I don't like to diagnose. You don't like to identify what the problem is? Well, I do identify what the okay. Well, I'm asking you, is there on a professional level, is there a diagnosable pathology in the family, like schizophrenia or like bipolar or like child psychological abuse or like a persecutory delusion? Is one of those pathologies present in this family? Yes or no? Good luck with that. I mean, they're going to, if they say no, none of those are present. You know, child abuse is psychological abuse is for a fact not present in this family by the allied parent. No, there is for a fact no persecutory delusion. Well, then did you assess for it? How did you assess for it? Where does it show that in the report? If they say, possibly, then they're stuck because they conducted an assessment and they didn't conduct a proper assessment. And are you telling me that even after your 6-month assessment that's cost all this money, you've met with everybody in the family, we still need another assessment for possible child abuse because you didn't even assess for that? And that's a critical question here. as to whether the target parent's abusing or the other parent's psychologically abusing Walters and Friedlander, and you didn't even bother to assess for that in your 6 months, and then they're kind of dead in the water. So cross-examining. Um, if a parent had schizophrenia, would you have identified that, diagnosed that, and told the court? Most likely they're going to say yes. If there was child abuse present, would you have identified, diagnosed that, and told the court? Most likely they're going to say yes. So when they say that they don't diagnose pathology because they don't like to, pathologize people, they're thinking personality disorders. They're thinking borderline or narcissistic, and that allegations go back and forth between the parents. What you're going to do is switch that up on them, and you're going to make it about the diagnosis of child psychological abuse. And so you can ask them, what are the 4 diagnoses of child abuse in the DSM-5? They may not know. It's physical, sexual, neglect, psychological. So psychological child abuse is a diagnosis in the DSM-5. Yeah. So would you diagnose that and tell the court, or do you just not diagnose child abuse when it's present and you don't think that's relevant to the court's decisions? Oh no, I would diagnose child abuse if it's present. Okay, well, child psychological abuse, that's a shared persecutory delusion, right? Earlier question. So if you didn't indicate any diagnosis, are you saying there is, for a fact, no shared persecutory delusion? I don't know what they're going to say to that. Yes, there is, for a fact, no persecutory delusion. Or, well, there might be. It's a possibility. And then they're stuck on that one. And that's your double bind. Are you saying there is, for a fact, no psychological child abuse in the family? So you're putting them into where they have to take an extreme position based on their assessment. And they did not assess for any of these things. So they can't really take that extreme position. But if they back off of it, then their assessment and the opinions as contained in the reports and recommendations are not based on information and techniques sufficient to substantiate their findings. Is it possible there might be a persecutory delusion? Possible, might, maybe. Tossing these qualifiers to make that seem like the safe answer in the middle, and the extreme answers are dangerous, which they are, but that's also dangerous, the middle answer. Should the child and family receive an additional assessment for a possible shared persecutory delusion? So that's their escape question that you're giving them. So after stressing them out and putting them in this situation where they're doing these risk managements on each answer and everything, and they're really scared up there because they're potentially documenting into a court record what's going to show up in their ethics board violation complaint to the licensing board, or a malpractice lawsuit, and for failure, misdiagnosis of the pathology and violations of ethical code standards, practice beyond the boundaries of competence and things. So after all this stress, you give them what seems to be an out. Should the child and family receive an additional assessment for a possible shared persecutory delusion? If they say no, that's an extreme position. No, I know exactly and this is what needs to happen. And the judge by this time, it's going to look at them and say, after all this other stuff, you're so confident. And so you've impeached their testimony. Or if they say yes, that the family should receive another assessment, then their current assessment, what was the point of that? That indicates it was inadequate, and they're in violation of 9.01 right from their answer on that. Those are called double bind questions, and they're available because the mental health people are thought disordered. It's not a linear logical line, and once you put them on a linear logical line, um, they become, you expose their thought disorder. So, should this family get another assessment for a possible persecutory thought disorder and a parent being imposed on the child? Um, See what they answer to that, yes or no, and then track them and start to expose their thought disorder right on the stand there. And should this family get another assessment for possible child psychological abuse by a parent? Phew, you just lead them step by step from one. So they say, yes, they should get it one for persecutory delusion, but you've already set that up as being linked to child abuse. So then you follow up, should they get an assessment for child psychological abuse? If they say yes, because it's logical, then that means they did not conduct an assessment for the child psychological abuse when that is the diagnostic possibility, differential diagnoses. That means they failed in their duty to protect. We have a possible child abuse from one parent or the other. And if they fail to conduct a proper assessment, risk assessment for possible child abuse, there's three dangerous pathologies: suicide, homicide, and abuse, child abuse, spousal abuse, and elder abuse. Whenever we encounter a dangerous pathology, we have to conduct a proper risk assessment or ensure that one gets conducted. So if they're saying that even after their assessment, we still need another assessment for possible child abuse, then they're saying they failed in their duty to protect obligations. So you can ask them that as a follow up. If they say, yes, they should get an assessment for possible delusional thought disorder, for possible child psychological abuse, then you ask them, so, doctor, did you then fail in your duty to protect obligations by not conducting a proper assessment for possible child abuse in this family? No, I did. Well, where in your report does it discuss the possibility of a persecutory delusion, the possibility of child psychological abuse by the allied parent? Where do you discuss that? So you didn't conduct the assessment. You're saying we need a new assessment. I'm thinking that's a linear logical line. You failed in your duty to protect obligations. The other feature about um, doing this or with these lines of questions is you don't need to necessarily go for the kill shot, although you may get it. What you're doing is you're demonstrating to the judge. When they start to dance around these questions and fail to answer the questions that are really linear and logical, that flow from one another, then it becomes evident to the judge that no, they're not competent in delusional thought disorders. No, they didn't conduct a proper assessment. And no, they didn't, their opinions are not based on information and techniques sufficient to substantiate their findings. Now, then you can either go for, convincing the judge that this persecutory delusion is present, the cross generational coalition stuff based on the symptom evidence. More likely and a little bit probably stronger is you're going to want to get a proper risk assessment done on this family. But that's going to be another assessment even after you get paid for this one and get all this one. We still need a clinical diagnostic risk assessment of the family. I would typically recommend, once you've had these custody evaluations, to roll that into the treatment. Don't get another assessment and then you try to get it. Get that on the treatment. All mental health professionals should diagnose the pathology before they start treating it. We need to know whether we're treating cancer or diabetes. So treatment should start with a diagnosis. If you get it out to the clinical psychologists and get away from these forensic people who are awful, just awful. So get it out to the treatment people. I recommend that moms out there, the targeted parent moms, look in the field of intimate partner violence, domestic violence, spousal abuse people, the therapists who are used to working with narcissistic men and spousal abuse. This is the pathology in the family courts is spousal abuse of the targeted parent using the child as a weapon. So they'll be able to recognize the narcissistic pattern that you're kind of caught in. For dads out there, targeted parent dads, I recommend you look in the dialectic behavior therapist community, and you can look in the cross communities as well. But because they're more familiar with the borderline personality and that they'll be recognize the borderline pattern of higher anxiety and the collapse into persecutory delusion kind of stuff. Um, but move it into treatment, and then get the proper assessment and diagnosis as start of treatment. um, I'm available consulting with the mental health people if they have questions or things like that. I'm of the opinion, strong opinion, that we should always go in with at least a second opinion on any of these diagnostic assessments, even at the start of treatment, because it's going to be a disputed diagnosis. We know that for a fact because it's in the court system. So one party or the other is going to dispute the diagnosis. The appellate system in for a disputed diagnosis in healthcare is second opinion, just like it is in the legal system. But rather than getting it, sequentially, get an opinion and then challenge it and get a second opinion and stuff, just do it right up front. That's what we do in healthcare. Doctor, this hurts. Well, let's get an orthopedic consult on this. And so let the doctors do what the doctors do. If opposing party wants to have their consultant in there as well, then we get a three-doctor opinion on this, which is a three-judge appellate panel over in the legal system. Legal system is totally familiar with how to deal with a three-judge appellate decision. And so in this case, we just have a three-doctor diagnostic decision. And if you get a bunch of doctors together, we should come up with roughly the same pathology. So if we're looking at the same information, the same tests, all of us should be in the domain of cancer. We shouldn't have one doctor saying it's high blood pressure. It's no. If three doctors, we might have disagreements about small pieces of things, but we should generally be in the same domain of what the diagnosis is. And if we have one strange outlier, then the judge can look at that and decide which of the doctors or which of the opinions out of the doctors seem to match the facts of the case. So I recommend we always get second opinions on that, and that's easy to do through telehealth. And psychologists, we do supervised stuff all the time. That's what's our training. We had 2 years of supervised training where somebody's watching what we do all the time, the one-way mirrors. So that's totally fine with doctors. So with the here we go. So the 9.01 question is, if you did not assess for a possible persecutory delusion in the family, are your opinions as contained in your recommendations, report, diagnostic, and evaluative statements, including your forensic testimony, based on information and techniques sufficient to substantiate your findings? It's going to be an interesting question for them because the answer to that is no. If they didn't assess for the pathology of concern, then no, it's not based on information, which is the delusional thought disorders, and it's not based on techniques, the mental status exam. The 2.01 question is, if you are not competent in the diagnostic assessment of delusional thought disorders, and the pathology in the family may be a delusional thought disorder, are you practicing beyond the boundaries of your competence in assessing this family conflict? The answer is yes. They're and I don't know what they're going to tell you. If they tell you yes, then you've got a licensing board complaint, documented in their testimony on either one of those for ethical violations. And if they say no, that's just not reasonable. That's not logical, and that's not rational. And the judge will identify that and say, no, they're just making stuff up to keep from getting him in more trouble. Yes, I didn't assess for delusional thought disorders, but it's based on information and techniques. And I don't even know how to do delusional thought disorders, but I'm competent with this pathology in the family courts. Walters and Friedlander, 4 times they mentioned delusions in the journal Family Court Review. They should know. Um, so with that, I'm going to close up my discussion of no diagnosis. When the mental health professional doesn't put a diagnosis on their reports, they're just opening themselves up for trouble because um, the if you don't put a diagnosis, you are asserting for a fact that there is no diagnosable pathology present in the family. And because otherwise you would have put it and told the court, especially around issues of like child abuse Or when there's allegations of child abuse, are those allegations due to a persecutory delusion? That's directly relevant to discuss and talk with the court. So personally, if I was coming up with, my forensic custody evaluation, I would just always put a section in on discussing family systems and look at applying, cross-generational coalitions and whatever the family systems constructs are relevant. Um, enmeshment, identified patient, whatever is relevant from family systems. I would have a section applying that. I would have a section discussing attachment pathology, including chronic, that we always repair attachment pathology when that's present in the symptom display. I would have for the court, I would have a discussion of a possible persecutory delusion. And I would either rule that in or rule that out. If it's ruled out that's a persecutory delusion, I would come back with a diagnosis of child abuse by the targeted parent. Why is that why are the child's fears and the other parent's fears valid? What is the evidence that leads me to believe that those are valid fears and have a reality base to them? That we have a narcissistic parent who presents a danger to the child, and we have a child protective response relative to the targeted parent. Okay. Yeah, I'm going to discuss that for the court. Or I'm going to discuss that it looks like a persecutory delusion, and I'm telling the court that these allegations of child abuse are due to a parent's thought disorder being imposed then on the child. So that should just be a standard part of these court-involved assessments, because those are the relevant kinds of diagnostic issues. And again, I'd pull in a second opinion right up front on these, because the doctors, the healthcare system, needs to return a diagnosis for the court that the court can rely on. And so, because if you believe a shared delusion, you become part of the shared delusion. You become part of the pathology. And when that pathology is child abuse, you become part of the child abuse. When the pathology is the spousal abuse of a parent using the child as a weapon, you become part of the spousal abuse. So the mental health professional, if you believe a shared delusion, and you, the court, if you believe a persecutory delusion. So that's why with this particular pathology of shared delusional disorder, a shared thought disorder, it is incredibly important that we return an accurate diagnosis, because one way or the other, we're making a decision. And if we misdiagnose the child abuse, then we're sending the child to be with an abusive parent. We're going to destroy that child's life. And so it's incredibly important. Judges are not trained to diagnose pathology. Doctors are, or should be. And so that's our role as doctors, to return an accurate diagnosis 100% of the time. The way we do that is with second opinion, or even third opinion if we need it, or with response to intervention, or with a variety of ways that we can implement and do to make sure that we return an accurate diagnosis when child abuse is considered, so that the court can then rely on that and act with certainty and not participate in the child abuse. I will also say that the driving this into the court system is a form of spousal financial abuse, but I'll discuss that in a different talk someday. So with that, I'm going to head off to my Sunday here. So good luck to everybody out there, and we'll check in next week about something else. Might stay continuing on the cross-examining mental health testimony, and going into maybe the ethics codes on this and the violations, and how that works. So with that, we'll talk to you guys later. Take care, everybody. Bye-bye.